Hello and welcome to my channel Happy Hours. In the last video, I discussed about the motions in the parliament, different parliamentary committees, questions in the parliament, and some important parliamentary terms. In this video, I'm going to discuss about the disqualifications of member of parliaments, anti-defection law, 91st Amendment Act 2003, Representation of People's Act 1951, and about the governor. So, what are we waiting for? Let's jump to the first topic, which is disqualification of Member of Parliament. It is mentioned in the article number 102. Grounds. First, if the MP hold an office of profit under the Government of India or any state government, other than the office declared by the Parliament, not to disqualify his holder. If the MP is of unsound mind and stands so declared by a competent court. Thirdly, if he is an undischarged insolvent, which means he has been declared bankrupt. Fourth one, if the MP has lost his Indian citizenship. And the last one, if the MP is thus disqualified under any law of the Parliament or of the Constitution, like anti-defection law, etc. An MP can be disqualified on the above grounds by the President, and his decision shall be final. But before giving any decision on question of disqualification, the President has to obtain the opinion of the Election Commission, and he shall act in accordance with such opinion. Now let us discuss about the anti-defection law. Defection means switching over from one political party to another political party. To check unethical defection, the Parliament passed the 52nd Amendment with Amendment Act 1985, which added the 10th schedule in the Constitution. This schedule has been termed as anti-defection law. The law is valid for the members of parliament as well as for the state legislatures. Under it, the grounds of disqualification has been mentioned. So now discuss about the grounds of disqualification. First one, if a legislature resigns from his or her political party. Second, if an independent legislature joins any political party, independent. And third, if a nominated member joins any political party after 6 months of his or her nomination. Fourth, if a legislator votes or abstains from voting contrary to any direction or order or whip issued by his political party, and such voting or abstention has not been condemned by his or her political party within 15 days of such voting or abstention. The Supreme Court has clarified that disqualification on the ground of non-compliance of a whip has to be only in the case of confidence motion, no confidence motion, cut motion, and the vote of thanks to the president's address. Whenever the survival of government is at stake, then whip should be issued. There is a condition under which there cannot be disqualification in case of defection. A member of legislature not to be disqualified when his or her original political party merges with another political party and he claims that he and any other member of his original political party have become the members of such political party or of a new political party formed by such merger. The merger of original political party of a member of a house shall be deemed or considered to have taken place if not less than two-thirds of the members of the legislature party concerned have agreed to such merger. If a person who has been elected as presiding officer of a legislature not to be disqualified under the 10th schedule, if because of his election to such office he voluntarily gives up the membership of his political party and does not become the member of another political party or rejoin his or her political party. The decision on disqualification of the members under the anti-defection law to be taken by presiding officer of the concerned house. Now let us discuss about the 91st Amendment Act 2003 and the anti-defection law. This Amendment Act was added has added a provision that a member of a legislature disqualified under the anti-defection law not to hold any remuneration political post or cannot be appointed as a minister till the completion of the term of the House or till he is elected again to the House. Now, let us know what are the grounds of disqualification of the people's representative under the Representation of Peoples Act 1951. If a legislature is found guilty of certain electoral offences of corrupt practices, if a legislator is convicted in any criminal case resulting in the imprisonment for 2 years or more, if a legislator has failed to submit an account of his election expenses within specified time, if the legislature had only interest in government contracts, works, or services, and if he or she is a director or managing agent or holds an office of profit in the corporation in which the government has at least 25% of stake. If the legislator has been dismissed from the government services for corruption or disloyalty to the state. And the last one is if he or she is convicted for promoting differences between the groups or has been punished for preaching or practicing social crimes such as untouchability, dowry, and sati. Next topic for today is vacation of the seats. It is mentioned in the article number 101. No person shall be a member of both the houses of the parliament. No person to be a member of the house of the parliament or of a state legislature. If a MP resigns and if the MP is disqualified under any law. If a member is absent for a period of 60 days from the House without the permission of the House, and the House may declare his seat to be vacant. There is a question in which we have discussed about the decline of Parliament at the contemporary time. First point for this is absenteeism among the members. There are two aspects. First is availability of lesser number of members in the law making process. And second one, sometimes the houses are to be adjourned by the presiding officer because of lack of quorum. Second point under this is lack of discipline among the members. By slogan shouting, use of unparliamentary languages, showing banners and posters, coming to the well of the house, tearing the copies of bills and other documents, low level of debates. Many MPs are having criminal background and corruption. Next topic is corruption. Where misuse of and or underutilization of MP local area development fund. MPs are authorized to give recommendation with respect to the petrol pump agencies and gas agencies, and it has been observed that many a times such recommendations are given by the MPs by taking money. Next is many MPs of the Rajya Sabha are not the residents of the state that they represent, which is against the federal character of the House. There are loopholes in the parliamentary committees, which we can understand that there is a lack of professionalism on the part of the member. Technically speaking, all the bills which are introduced in the houses of the parliament are to be referred to the concerned department related standing committees. But it has been observed that all the bills are not referred to the parliamentary committee, and only the bills on which the government wants to buy time are generally referred to such committees. The recommendation of the parliamentary committees are also not binding. Now, by the end of this, want to suggest some reforms needed in India. First is to check absenteeism. Article number 101 needs to be amended. Second, the former Vice President Sri Venkaiah Naidu had suggested that the political parties should ensure that the attendance of at least 50% of their members all through the proceedings of the houses by adopting a roster system. Next, the sessions of the houses to be extended to make up for the time wasted because of the frequent adjournment. Another suggestion is there should be strict enforcement of code of conduct by the presiding officers. There should be conducted training programs for the newly elected members and refers her courses from time to time for the members to make them aware of the national and international issues. There should be a refreshment course also, so that they can contribute meaningfully um, during the discussions. Next one, there should be appointment of experts in the parliament. Any committees to assist the members in the in understanding the technicalities of the ministries and the bills presented in the legislature. To make the legislature more effective, there is need for detailed framework based pre and post legislative assessment. Every legislative le- proposals or bill shall incorporate a detailed account for social, economic, environmental, and administrative impact for wider awareness and subsequent assessment of the effects of the legislative on the ground. There is a need for streamlining of parliamentary procedures, and there should be clear-cut allocation of time of debate between the ruling party and the opposition. The government should be responsive to the concern of the opposition, and the opposition should be responsible and constructive during the debates, and while criticizing the government and opposing legislations. Now we are proceeding to the next topic for today, that is the state and the government. The governor is thus this is described in the article number 153, which provides for the governor for each state. The same person can be appointed as governor of two or more states. Where the same person is appointed as governor or two more states, the emoluments and allowances payable to the governor is to be allocated among the states in such proportion as the president may by order determine. Article number 154, clause 1, ways that the executive power of the state in the governor, which can be exercised by him either directly or through officers subordinate to him, means by the civil servant. The governor is appointed for the term of 5 years from the date on which he enters upon his office. The governor is appointed by the president and he holds the office during the pleasure of the president. The emoluments and allowances of the governor not to be altered for his disadvantage during the term of his office. Now there is a question in which there is a discussion why an appointment of the governor, why the governor is appointed, why not he is elected. The views discussed in the Constituent Assembly, there were three views which were discussed. The first view was the governor to be directly elected by the people. The second one, the governor to be elected by the MLAs of the state. And the third and the last view was the governor to be appointed by the president. In the first view, during the discussion on the first view, there was a general feeling among the most of the members that if the governor as well as the ministers are directly elected by the people, then there may arise conflict between the two authorities with respect to legitimacy and a conflict between the two may not prove to be healthy for the administration of the state. During the discussion of the second view point, the logic have been a governor is a federal system was discussed. In a federal system, the governor is to act as the representative of the center, and the governor elected by the MLAs of the state may not be able to discharge the responsibilities in a desired manner, and he may be biased towards the state. So the third view was prevailing. By this, I'm concluding my video for today. Thank you.